Welcome to the first section of our training. Overview of Title IX and the Violence Against Women Act, or VAWA. This section will highlight the following. What is Title IX? What is VAWA? Definitions as they relate to both. INWAC responsibilities regarding both. Role of the federal government as it relates to both. INWAC policies regarding both. And prohibitions on retaliation. Title IX is a federal law that states, no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So, what does that mean? Title IX applies to all schools receiving federal funding. Yep, that's us. Title IX mandates that all those institutions must ensure equal treatment for male and female students and employees, and it protects against sex-based discrimination, including sexual harassment, sexual violence, and pregnancy discrimination, ensuring a fair and equitable educational environment. The Violence Against Women Act, VAWA, enacted in 1994, aims to raise awareness of domestic violence and assault crimes against women. Before that time, there was minimal awareness, despite the high frequency of these crimes. The 2013 reauthorization expanded the Clery Act to include dating violence, domestic violence, and stalking. It mandates institutions to implement preventative education programs, such as our Red Flag Bystander Intervention Program. The Act mandates institutions establish policies to address those crimes. It also impacted hate crime bias categories under the Clery Act by adding gender identity and separating national origin and ethnicity. We will now transition into the definitions section. Both Title IX and the Clery Act contain identical or closely aligned definitions for the crimes identified under the Violence Against Women Act. For definitions that are similar, we will focus on the Title IX definition and highlight any distinctions found in the Clery Act. To begin, we will review the official 2020 Title IX regulations definition of sexual harassment, which states, sexual harassment means conduct on the basis of sex that satisfies one or more of the following. 1. An employee of the college conditioning the provision of an aid, benefit, or service of the college on an individual's participation in unwelcome sexual conduct, such as a college employee requiring an individual to participate in unwanted sexual behaviors in exchange for receiving aid, benefits, or services. See definition for quid pro quo. 2. Unwelcome conduct determined by a reasonable person to be so severe, pervasive, and objectively offensive that it effectively denies a person equal access to the college's education program or activity. See definition for hostile environment. Or 3. Sexual assault, dating violence, domestic violence, or stalking, as defined by the Violence Against Women Act. See definitions. The first two Title IX definitions from the last slide are specific to Title IX. Let's look a little closer at those. Hostile environment, sexual harassment. Any situation in which there is unwelcome, harassing conduct that is sufficiently severe, pervasive, and objectively offensive that it alters the conditions of employment or limits, interferes with or denies educational benefits or opportunities from both a subjective, the alleged victim's, and an objective, reasonable person's viewpoint. Quid pro quo sexual harassment. Any instance in which a college employee conditions the provisions of an aid, benefit, or service of the college on a student's participation in unwelcome sexual conduct, such as, I'll give you a good grade if you have sex with me, or I will be sure you get that promotion if you have sex with me. In the first definition, notice that the conduct must be sufficiently severe, pervasive, and objectively offensive. That means it must meet all three of those conditions. There is a document in your handouts that helps you determine those thresholds. Now let's dive into the definitions that are either the same or similar. Let's start with sexual assault. The Title IX definition and Clery definitions are the same and include rape, any penetration, however slight, of a person's vagina or anus by any body part or object, or oral penetration involving a sex organ, when performed without the person's consent. This includes situations where the individual is unable to give consent due to age, or because of a temporary or permanent mental or physical incapacity. Incest. Sexual intercourse between persons who are related to each other within the degrees wherein marriage is prohibited by Arkansas law. Statutory rape. Sexual intercourse with a person who is under the statutory age of consent. In Arkansas, the legal age of consent is 16 years old. Fondling. The touching of the private body parts of another person for the purpose of sexual gratification without the consent of the victim, including instances where the victim is incapable of giving consent because of his/her age or because of his/her temporary or permanent mental incapacity. Domestic violence. In the context of sexual misconduct, domestic violence is violence on the basis of sex committed by a responding party who is a current or former spouse or intimate partner of the reporting party, or by a person with whom the reporting party shares a child in common, or by a person who is cohabitating with or has cohabitated with the reporting party as a spouse or intimate partner, or by a person similarly situated to a spouse of the reporting party under the domestic or family violence laws of Arkansas, or by any other person against an adult or youth reporting party who is protected from that person's acts under the domestic or family violence laws of Arkansas. For Cleary, the violations are not just sex-based. Cleary states, a felony or misdemeanor crime of violence. Domestic violence victims by Arkansas law are defined as family or household members. Arkansas defines family or household members as current or former spouses, parents and children, persons related by blood, a child living in the household, persons who currently or previously lived together, people who have a child together, and persons who currently or formerly were in a dating relationship. Domestic violence can happen to anyone, regardless of race, age, sexual orientation, religion, or gender. Domestic violence affects people of all socioeconomic backgrounds and education levels. Domestic violence occurs in both opposite-sex and same-sex relationships. Dating violence. For the purposes of Title IX, dating violence is defined as violence on the basis of sex committed by a responding party who is in or has been in a social relationship of a romantic or intimate nature with the reporting party. The existence of such a relationship will be determined based on the reporting party's statement and with consideration of the length of the relationship, the type of relationship, and the frequency of interaction between the persons involved in the relationship. For the purposes of this definition, dating violence includes, but is not limited to, sexual abuse or the threat of such abuse. Dating violence does not include acts covered under the definition of domestic violence. For Cleary, dating violence includes, but is not limited to, sexual or physical abuse or the threat of such abuse. Stalking, a pattern of repeated and unwanted attention, harassment, contact, or any other course of conduct on the basis of sex directed at a specific person that would cause a reasonable person to feel fear for his or her safety or the safety of others and/or suffer substantial emotional distress. For the purposes of this definition, course of conduct means two or more acts, including, but not limited to, acts in which the responding party directly, indirectly, or through third parties, by any action, method, device, or means, follows, monitors, observes, surveils, threatens, or communicates to or about a person, or interferes with a person's property. Substantial emotional distress means significant mental suffering or anguish that may, but does not necessarily, require medical or other professional treatment or counseling. Cleary is not on the basis of sex only. Cleary's opening statement is a bit different, engaging in a course of conduct directed at a specific person that would cause a reasonable person to fear for the person's safety or the safety of others, or suffer substantial emotional distress. A couple of things to note before we move away from definitions. 1. The big difference in VAWA coverage under Title IX and Cleary is Title IX covers only sex-based offenses. Cleary covers all. Understanding these distinctions is crucial for effective policy implementation and compliance. 2. It is important to note that VAWA, while it says women, covers all genders. One of the training requirements is to ensure that you know INWAC's responsibilities and the role of the federal government under the Cleary Act and VAWA. Let's take a look at INWAC's responsibilities under Title IX. There are 3 essential compliance elements. 1. Stop the discriminatory conduct. The institution must take immediate action to end the discriminatory conduct as soon as they are aware of it. 2. Prevent recurrence on both individual and institutional levels. This refers to the institution's responsibility to prevent the discrimination from happening again to the specific individuals involved and within the larger school community. For the individual, this may involve implementing measures like no contact orders or adjustments to class schedules to minimize contact between the parties. For the institution, this could include measures like developing and distributing sexual violence awareness materials, providing prevention programs and bystander intervention training, such as our Red Flag campaign, increasing security in certain areas of campus where incidents may have occurred. 3. Remedy the effects of discrimination for both the individual and the community. This means addressing the harm caused by the discrimination to the victim and the broader school community. For the individual, this may involve providing the reporting party with access to counseling, medical services, academic support, and allowing them to make academic adjustments without penalty. It also includes sanctioning for the responding party if found responsible. For the community, this includes addressing the broader impact of discrimination on the school environment by implementing measures that foster a more inclusive and respectful culture, such as conducting campus climate surveys to assess the effectiveness of prevention efforts, implementing new security procedures on campus, ensuring that students and employees are aware of their rights under Title IX and the procedures for reporting and resolving complaints. Schools are also required to designate a Title IX coordinator. Ours is Teresa Taylor. Provide a notice of non-discrimination. INWACs can be found in several of our policies. Links to these will be at the end of the training. Provide equitable opportunities for all students and employees. Develop and implement policies to address and prevent sexual discrimination and harassment. Establish and publish clear grievance process. This can be found in our Policy 2003, the Student Handbook, and our Annual Security Report. Provide supportive measures. We will talk about those in a future section. Provide and receive training annually. Yay, that is what we are doing now. INWAC's responsibilities under the Clery Act and VAWA include develop and implement policies to address and prevent campus violence. Publish annual security report. INWACs can be found in Policy Stat. Maintain a public crime log. Ours is located in the Maine Department of Public Safety Office in CHP. Provide prevention and awareness training. Our Office of Community Standards, as well as the Counseling Center, host several events a year. Provide prompt, fair, and impartial disciplinary proceedings. Provide protective measures. Provide written explanation of victim rights, options, and resources. Annual training for campus security authorities and those involved in the disciplinary process. Issue timely warnings and emergency notifications. These will come from our Office of Risk Management and Department of Public Safety. What is the role of the federal government in enforcing Title IX? The Department of Education Office for Civil Rights enforces Title IX by investigating complaints, conducting compliance reviews, providing technical assistance to institutions of higher education, IHE, initiates proceedings to terminate funding or refer case to Department of Justice, DOJ, and what is the role of the federal government in enforcing VAWA under the Clery Act? The U.S. Department of Education, ED, ensures compliance through the Clery Compliance Group within the Office of Federal Student Aid. This office conducts program reviews, provides training and technical assistance, can impose fines for non-compliance, including civil fines and suspension from federal student aid programs. Current fine for violations is $71,545 per incident. Another requirement is ensuring adjudicators know how and where to locate policies that relate to Title IX and VAWA. INWAC Policy 2003 addresses sex discrimination, sexual harassment, and sexual misconduct. This is where the Title IX grievance process is lined out. This is also one of the places you can locate our Notice of Non-Discrimination. Policy 9010 focuses on campus safety and Clery compliance. The 2024 Annual Security Report provides transparency. The links on this page will also be copied to the last page of the training module. You are encouraged to become familiar with them. Title IX and the Clery Act mandate that institutions must prohibit retaliation, including peer retaliation and retaliation against individuals for exercising their rights by filing a complaint or participating in an investigation. The full text of the Title IX, Clery Act, and INWAC prohibition on retaliation is in your handouts. INWACs may be found in Policy 2003. This is the end of Section 1. Section 2 will cover reporting and confidentiality.